This is Radio Law Talk. And now, back to the show.
So we're talking about Weinstein. We're going to go into the closing arguments by the defense and some interesting things. Go ahead. You had a question?
Well, yeah, we're closing arguments by the defense, and some of you, again, we talked about this before, who maybe think, well, wait a minute, doesn't the prosecution go first? Again, in some states, the prosecution goes first, but in New York, the defense gives closing arguments first, and then the prosecution finishes. They don't do a 1, 2, 1. It's just defense, prosecution, done.
Done. And so this is on a Thursday, and then Friday, which was yesterday, the prosecution lays their they already laid their case out. They have their closing arguments. And then they take a recess for next week. The jury has all week to think about it. They're not supposed to. They're told, you're supposed to go home and be normal. But when you come back next week, next Tuesday, you're going to discuss it and try to make a decision. So what does defense say? Defense stands up and says, like I said during the break, be New Yorkers and use your common sense. And it's important for you. The argument is by defense, by Harvey Weinstein's defense, is if you have any doubt, if it's beyond a reasonable doubt, don't forget, they go into the beyond a reasonable doubt issue, that you can't just say, oh, you know what, they're probably guilty. No, it's got to be beyond a reasonable doubt. We've discussed that many times. We don't want to get into that. But they said, be brave and say not guilty, because they go into a number of things saying he is not the monster that you as in, over on the other side, or that the media has portrayed him to be. You have to go by the facts that were presented to you, not by the media or the sensationalism. And this is what prosecutors, defense people say a lot. I'm sure you have too, Todd. Mm-hmm. You don't have to like the person. We're not saying you have to like Harvey Weinstein. This is what their argument is, by the way. I'm not arguing it. You don't have to like him. And we're okay with you not liking him. That doesn't mean he's guilty. And that's the thing that the defense sat there and hammered on. And then they go on and say every single one of these women, and the closing argument is by his lawyer, who's a woman.
Yes.
Every single one of these women reached out and asked for these things from Harvey. She brought up an important point, and she makes some great arguments. And we're going to, whether you disagree or agree, we're going to talk about some really good arguments she made, which is he didn't reach out to them. They reached out to him.
But you made a great, I think you kind of scratched on a great area here, Fred, and that is you don't have to like this guy. Do lawyers, and either of you've both tried a lot of cases, do you ever look at the jury and say, you don't have to like me, just listen to what I'm saying? Because I don't think, having covered a lot of cases in the courtroom, I don't think juries like a lot of attorneys. They resent the fact that they're there in most cases, taking their time. Do you ever say to them, please don't pay attention to whether you like me or not, just listen to what I'm saying, or something like that?
No, Cal, I never do that because they always love me. The juries love me.
Well,
so I just say,
point.
hey,
Sorry,
just because you like me, give me the verdict.
Of course.
That's what's the complete opposite. No,
I'm
I
sorry
don't do
about
that, Cal. I can't believe you questioned that they didn't like me.
Well, I didn't mean you personally. I meant in generic. You.
Todd, they all like you too, right?
Well, they sure.
Go with that.
Here's the thing. As a defense attorney, if you have to cross-examine a victim on the stand and you have to get into things that they said that are uncomfortable, and then the victim starts crying, what is the typical reaction when you see one person talking to another person and the other person is being made to cry? You immediately think that they're being beat up upon. It doesn't matter what the subject matter is. You look at it and you go, my heart goes out to them. That's sometimes a difficult thing for a defense attorney to overcome.
But here's another issue. So they also argue, don't forget, ladies and gentlemen of the jury, this is Weinstein's attorney. It's about two women, Miss Haley and Miss Mann. It's not about the other four. Remember that those two are the two you're looking at, whether you believe them or not. And then she argues, it's not an issue with those other four prior bad acts testimonies. Now, you could take that into consideration, obviously, but she's basically saying it's about Miss Haley and Miss Mann. And this is what she says that I said to myself, and I wrote on my notes next to it, I wouldn't have said it just like that. And she says, quote, in the end, it comes down to those two. The lawyer said, this is the lawyer that said about Haley and Mann, quote, if you don't believe Miss Haley or Miss Mann, you don't have to evaluate anything else. what I would have said there, and again, this is armchair quarterback. By the way, this closing argument was phenomenal. I would have gone on and said, even if you do believe some other stuff they say, was it beyond a reasonable doubt that there's some doubt some stuff was not true, even if you do believe some of it? See what I'm saying? So I would have put in, because she basically said, if you don't believe them, then that's too extreme. You know what I'm saying?
And you have to remember the argument before the pretrial motions, when the prosecution said, look, we are calling these people for their past experiences. They're not in the complaint, but we're calling them for their motive. The defense specifically argued to the court, if you let those people testify, the jury is going to try to convict my client of offenses against Haley and Mann, and they're going to do it because they don't like his conduct against these people that he introduced for motive. And the judge said, well, I think the jury will be able to understand that this is only being used to show motive and scheme, and they'll know that it's that this isn't being offered as if he did it here, he did it here. It's just to show his modus operandi, so to speak. They won't convict him because they don't like this. They're just using it for that. Well, if the judge makes that ruling, then the defense has to remind the jury that's the only reason this stuff came in. The only reason. And if you don't believe Mann and Haley,
doesn't matter.
None of that stuff matters.
And here's the thing: then what she comes in with, that's a little bit soft. Believe it or not, this is soft. Then she starts hammering. Here's the hammer. Miss Haley, quote, is a flirtatious person. And Mann, she goes on to Miss Mann and says she has been used by the state of New York and the prosecution. And she says, I feel sorry for Miss Mann. She is a victim of the state of New York. Wow, what a great argument. I think, and again, we're lawyers here talking about the argument. What a great argument that is. And then she goes in and says the following, more hammer. Now the hammer's getting heavier. Hammer. Both women, she said, used Weinstein to benefit their career. And as of Miss Mann, she made a choice that she wants to be in this world, that is this career, this world of Hollywood type of world. And she made the choice that he could have potentially provided her stuff that she wanted.
Doesn't it sound to you, Todd, that she wants it both ways, that she's saying, don't victimize. This person's been made a victim, but let's beat up this alleged victim. I mean, it's like
when you say she, the prosecutor, or the defense attorney.
Defense attorney saying, now I could be wrong, but it sounds to me like that's two different things came out of her mouth in that
Here's
argument.
the brilliance that I see in this argument, and it's because when you're talking to a jury like that, you're concerned that the jury is going to face this dichotomy that doesn't really exist, which is if I acquit Harvey Weinstein, then I have to admit that this person is not a victim of anything. And now, because of this argument, they are allowing the jury to say, hey, you can acquit Weinstein and still view her as a victim. It's just she's not a victim of Weinstein. She's a victim of the state. And now mentally they're allowed to have that, both of those things where I can still accept her as a victim and acquit Harvey Weinstein.
That was pretty smart.
I think that's brilliant the way she does that.
She talks about, look, now prosecution's going to be able to get up. Just remember, I can't say anything after that. I'm done. Remember, she kind of insinuates that's not fair, but that's the way the process is. And she said she's going to be a tiny bit loud, and she's going to have the last word, and she's going to draw on your emotions. Don't let her do that. And she goes into that, and she does the final kind of like boom. And it's an interesting thing. She gets into women and women's rights, kind of. I'm not going to say rights, but how women are treated. And she plays the kind of the prosecution and New York as victimizing women, that they cannot make their own decisions when they come in and do things like this. That women, it's stripping women of any ability to make their own decisions, stripping women of the choices they make, and labeling it as something else. Man, she's hammer, big hammers. Go ahead. Todd, you had a question?
Well, the only thing I was going to say is the arguments that you've heard her make is exactly why Weinstein wanted a female to make the argument as opposed to a male, because if a male is making these arguments, it comes off as too paternalistic, biased. It just wouldn't work.
Great point.
Yeah, well,
Great
quick point. We have 30 seconds, really quick. The final things, and we'll get into what the prosecution says. You don't have to like Mr. Weinstein. This is not a popularity contest. And you, she says, are the last line of defense in this country from an overzealous media. And then when we come back, we're going to talk about what prosecution has to say.
It'll be interesting how the jury responds to all of that. I guess we'll find out in time. In the meantime, speaking of time, we're out of it for this segment.
Just a tip from your friends at Radio Law Talk.
Be sure to read our disclaimers on radiolawtalk.com as well.
I like the Amargosa Valley.
Radio Law Talk and radiolawtalk.com.
I went to fist bump him, and Todd, and he ignored me.
I left him hanging on the fist. Okay, I'll give you the fist bump back. Okay.
Go. You wanted to bring something up that we ended with. We're going to start with the prosecution's closing argument. You said, I got to say something else.
Yeah, because, look, they can't get around in this case that you're dealing with something that is claimed to be a part and parcel of the Hollywood experience and what's going on, what goes on in the acting world, or allegedly goes on in the acting world. And so this defense attorney weaved in a Hollywood-type motif, or metaphor in explaining this. And she said, I quote, "The assistant district attorneys are the producers in this case, and they are writing the script. In their universe, women are not responsible for the parties they attend, for the men they flirt with, for the jobs that they ask for help with. In this script, the powerful man is the villain, and he's so unattractive and large that no woman would want to sleep with him voluntarily." Now, look, I'm just going to put aside whether or not that argument makes sense, whether it's supported by the facts or what have you, if it is a defense or not. All I'm saying is, rather than getting up and blandly stating as part of the defense, this is the evidence, do this, she weaves it into something, a story, in hopes that people can identify. And in my opinion, it's a brilliant move to try to illustrate the point, because it's something that people can identify with, because we've all seen movies, we all know that. This was just very well done on her part, just from a trial tactic standpoint. I guess it remains to be seen whether or not it was effective. Jury starts deliberating Tuesday. But they heard the prosecution's argument.
The prosecution stands up, and guess how they start out?
Oh,
they start out
tell.
right at the beginning. They said he's an abusive rapist. First thing they said. Now, one of the first main things they said. They said he manipulated women in order who were first coming into the industry because of his power. But here's the interesting thing, that all these scenarios they use, I think, are interesting. And again, as lawyers, we know this is serious, but as lawyers, we look at the tactics. He is, quote, the closing argument said, the lawyer for the prosecution, he is, quote, the master of his universe and the witness here were really ants whom he could step on without consequences. Yikes. And he talks about, and she goes into about how he stays in touch with them. They have to come up with the argument. How are they going to overcome the argument that these women, especially Miss Mann, said this, brought these horrible allegations, and then continued to go out with him and be his friend? And basically their argument there was he kept in touch with them as a check. In other words, they're like a little check to make sure they would not make accusations against them. In other words, kind of held them captive as a friend or girlfriend and stayed close with them.
Right, to just keep a tether on them and make sure they don't get away and tell what's really going on. But the question is the defense implying indirectly here that if you wish to be in the movie industry, the casting couch is how the game is played, and that's, you make the choice? Then there is that kind of what she's saying? Because I don't think that'll fall well on the jury's ear, will it?
Yeah, but we're talking about the prosecution now, but that's the prosecution has to get around that, Cal.
Right, that's my point.
How are they going to get around that? 855 Law Radio, if you want to call in. Again, 855 Law Radio. But they have to, the gorilla in the room is exactly what you said, Cal. They not only voluntarily, their argument is defense, they voluntarily had relationships with him, was what their argument is, and not only that, kept going after that.
Right.
So that's why they have to say that's his MO. That was the prosecution's argument. That's the MO, ladies and gentlemen of the jury. That's he kept a little check on them to make sure he controlled. And that's kind of what they were getting at.
And I would say that to talk about the prosecution's argument and how it ties with your question, Cal, would be this. The crime here should be that Weinstein, and the element should be that Weinstein acted in a way that deprived the women of an actual choice whether or not to engage in sexual activity with him. That is the way that the jury instruction, everything should be written. They were adults, and he deprived them of an actual choice through actual force. They could not get away. It should not be, this is the defense argument, it should not be he deprived them of a palatable choice, because if they decided not to, then their career would go away. Things would be unpleasant if they didn't. That is, you still have the choice, you just don't necessarily like the consequences if you don't. That seems to be the defense argument and the key distinction between those two. And, look, the allegations, you're talking about all this, but the allegation here from these women isn't, man testified that she engaged in activity with him, or he towards her, and she didn't want to do it, and he forced himself on her. So they're arguing, the prosecution is arguing that this was a deprivation of actual choice. So the jury shouldn't be confused to think, well, I don't think it was that, but boy, it was still unpalatable, so we'll convict anyway. If that's their thought process, no, you shouldn't convict. So
yeah, she goes on and says, and this is, I put good argument. This really, the prosecution, and it's Miss Aluzzi
yeah.
Yeah, Miss Aluzzi is the prosecutor that is handling these closing arguments. The question for you is not whether Jessica Mann made a bad decision, and Cal and I talked about this earlier. She said it's when talking about Mann's relationship concerning Weinstein. Did she make a bad decision? And their argument is that's not the issue. The issue is whether Miss Mann is lying about what happened. And if she's telling you the truth, then these allegations are true. And that's how she diverts and goes around the issue that, you know what, yeah, she made bad decisions. We're owning it. And she even says she owns her behavior. 3 days worth of testifying.
Yeah.
She owned all the bad things that she did or things that she messed up on. She owned it. And so that's a good way to say you're right, but that still doesn't mean she wasn't assaulted.
That's true. That's true. I think the most difficult thing going forward at this point is whether or not the jury can maintain the discipline of applying the right standard beyond reasonable doubt. And it's because we don't normally do that. If I get an argument with my kids, it's just like, okay, who do I believe more? Do you? And that is the basis by which we handle so many arguments these days, that asking a jury of 12 people to shift from the way they handle arguments probably 95% of the time to this standard is difficult, and they shift and they fall back into what they normally do. It's going to be a test of their discipline.
Now, doesn't this just prove the point that usually in most cases, Fred and Todd, that there's not an obvious, clear delineation, that none of these things are clean? You go in and it's just not cut, dried, boom, boom, boom. It is some sort of gray area in between, not a binary choice for a jury. Is that
well,
false?
I would say that if it were cut and clean like that, you could probably try these cases with a computer. Just input the evidence, and whatever the computer says, that's the verdict. So you're right. It is judging credibility, and it's never clean.
Wow.
Interesting.
I think I got a new business now.
Yeah.
You just gave us all a good business tip.
A computer
lawyer.
I don't know. If it's the same algorithm that got us booted from Twitter because we even posted about Weinstein, I'm not certain I trust that.
I don't know about that. Anyway,
AI legal firm.
Yes.
We're ending this. So that's Weinstein. We're going to follow up with you next week. We're going to
Go to the website, radiolawtalk.com. That's radiolawtalk.com.